Appellate Courts. Those are the courts that hear the appeals of the lower courts. The key courts of appeal include the Divisional Courts, the Court of Appeal, and the House of Lords. Divisional Courts. Every section of the High Court includes what is called the Divisional Court, which has the authority to consider appeals from lower courts and tribunals. In certain cases, 2 to 3 of the judges in the same division will work together and consider the argument. Queen's Bench Divisional Court. The most important of the divisional courts is the Queen's Bench Divisional Court. This has 2 main functions. It hears appeals by way of case stated from criminal cases decided in the Magistrates Court. This is dealt with more fully later. Each has supervisory authority over lower courts and tribunals, as well as over the acts and judgments of state authorities and cabinet officials. This procedure is known as Judiciary Examination and, for this reason, the court has the authority to impose what is regarded as prerogative orders. Such directives are a compulsory order, which is an order to fulfill a duty, a prohibitive order, which is an order to preclude a lower court from considering a dispute that it has little authority to contend with, and a quashing order, which excludes a ruling from the Queen's Bench Division so that the lawfulness of the judgment can be checked and the ruling quashed if determined to be unconstitutional. The Queen's Bench Divisional Court also considers habeas corpus appeals by people who say that they are illegally imprisoned. This is an effective step to defend the right to democracy. Chancery Divisional Court. This involves only a limited number of appeals, in particular the rulings of the tax commissions on the collection of taxes and the appeals of judgments of the county court in situations of bankruptcy. Family Divisional Court. The main function of this court is to hear appeals from the decisions of the magistrates regarding family matters and orders affecting children. Court of Appeal, Civil Division. The Court of Appeal was created under the Judicature Act 1873 and was originally meant to be the last court of appeal. Nevertheless, the status of the House of Lords as the last appeal court was established by the Appeal Jurisdiction Act 1876. The Court of Appeal currently has 2 parts, civil and judicial. There are 38 Lords of Appeals, and each section is led by its own member. The Civil Division is the primary court of appeal for civil litigation, which is managed by the Master of the Rolls. The Court of Appeal, Civil Division, mainly hears appeals from the following courts. All 3 divisions of the High Court. The County Court for multi-track cases. The Upper Tier Tribunal. Permission to appeal. For certain cases, the authorization to appeal is needed. This can be provided by the lower court where the action has been made or by the Court of Appeal. Permission to appeal will only be given if the court determines whether the appeal will have a reasonable chance of success or if there was any other legitimate cause that the request would be considered. Permission to appeal is not necessary in situations where the individual's liberty is at issue, for example, in an appeal against a jail term for violation of an injunction.